This is Wednesday, September 7th, 2022. I am Judge Martin. This is courtroom number 1. This afternoon's docket is exclusively landlord-tenant hearings. If you do not have a landlord and tenant matter, you are in the wrong courtroom. You should check your notes and get logged in where you are supposed to be. If you are not sure where you're supposed to be, you may send a chat message to the staff and they will help you get where you are supposed to be. Mr. Jones, you cannot smoke in court. You cannot wear a hat in court. Nope. Thank you.
I just put it out.
Thank you, sir.
What?
That being said, this is 2-2. Oh, maybe not. The attorney's not here. This is 2-2-2335 LT. This is Holiday West versus Crystal Smith and Donovan Smith.
Ready, Your Honor. Good afternoon.
I'm here.
This is Daniel Marchese on behalf of plaintiff.
Mr. Marchese, your P number, please.
Oh, yes, ma'am. 75872.
Thank you. Ma'am, state your name for the record.
Crystal Smith.
Ma'am, are you driving or are you the passenger?
I'm a passenger.
Where
I'm gonna have a pullover.
Where is Donovan Smith?
He works. He's at work.
So he will not be attending this afternoon's hearing regarding housing.
No, ma'am.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay went into place back on June the 8th, 2022. 91 days have passed. Ms. Smith, has your Sarah funding been approved?
She just got a hold of me on Friday, this Friday, and me today and yesterday. She needed paperwork, so I gave her one more paperwork, and she said she's working on my case right now.
Mr. Marchese?
Yes, I mean, my client would like to obviously get paid. I mean, ma'am, like, did they give you a time frame on how much longer it's going to be?
That's all she had told me, that she's working on it right now.
Ms. Smith,
Okay.
raise your right hand for me, ma'am. Do you swear a firm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Sir, how much rent is due and owing in this matter?
Ma'am, rents to retain is $6,899.62. Court costs.
I'm sorry, and 60 what cents, sir?
$6,899.62, $198 in court costs, for a total amount of $7,097.62.
Ms. Smith, is there rent due and owing in this matter of $6,899.62?
Yes, ma'am.
Has your Sarah funding been approved?
I'm not sure yet. She's working on it right now, so I don't know if I'm approved or not. She's doing my
When was the last time that you made payment on your rent?
Since I want to say March.
Ms. Smith, the reason why we're here this afternoon is on plaintiff's request to lift the Sarah stay. Inasmuch as your Sarah has not paid the past due rent and the plaintiff's office has not received information that you've been denied, this court is required to lift the Sarah stay and will do that. Secondly, inasmuch as you admit and acknowledge that the rent due and owing as set forth by the attorney is true and accurate, there remains no tribal issue and plaintiff is entitled to entry of judgment in this matter with rent to retain possession of $6,899.62, $198 in court costs for a total judgment of $7,097.62. Plaintiff's office may submit that judgment for entry.
Okay, that sounds good, Your Honor. And let's see, let me look at the calendar. If you give me just a moment, I'll give her, I'll extend the writ into the 23rd just to see if it pays, if that's okay with the court.
Ms. Smith, what will happen next is that Mr. Marchese's office will submit that judgment to the court. Court will sign it. A copy will be mailed to you once you receive it. I suggest that you get back in touch with the Sarah agency that you apply with and advise them that you have until September 23rd to pay or move. That might help expedite the processing of your application. Anything else, ma'am?
No, that'll be all.
Thank you, ma'am. Have a good day.
You too.
Thank you. This is two-two-two-six-two-one LT. This is Bill Properties versus Kevin Jones.
Yes. See, ma'am, the reason we're having this problem right now is because you said my
Sir,
name.
no. That's not how this works.
Okay.
First, the attorney says his name, then you
Okay.
say your name, and then we'll get into the hearing,
I
okay?
already-
Thank you.
Thank you, Your Honor. Corey Grandmason, P 64392, representing the Beal properties at this time.
Thank you. Now, sir, state your name for the record.
My name is Kelvin Jones, not Kevin Jones.
Mr. Jones, do you live at 6339 Middle Belt Road, number 4?
Yes, ma'am.
Thank you. Mr. Jones, today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place for 84 days. Has your application for Sarah financial support been approved?
It's been denied. But the same day it was denied, it was denied because I resubmitted a whole new application to Sarah, and when I was supposed to go back through with them with the other with my number that I originally had. So they denied me. But Wayne Metro, they put me into another program, and they tried to reach out. I got emails and everything. They tried to reach out to Bill's property, but Bill's property never responded because for some reason they had my name down as Kevin Jones, and they kept telling Wayne Metro that they didn't know who Calvin Jones was. And then finally, I kept emailing and calling Bill's property. I finally got a call back from the property manager, and we kind of corrected that thing. I went back to Wayne Metro. This was like middle of August. They said they don't know if they could help me or nothing, but just yesterday they sent me an email with the new program, and I put the application in this morning. I work midnight.
Mr. Jones, raise your right hand for me, sir. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Nothing but the truth.
Thank you, sir. You can put your hand down. And as much as more than 45 days has passed and there has been indication from you, sir, that your Sarah application was denied, this court is required to lift the Sarah stay that's been in place since June the 15th. Mr. Graham Mason, how much rent is due to retain possession?
At this point in time, Your Honor, the rent to retain possession is $7,100. Costs in this matter for filing, service, and attorney's fees is $164.53, excuse me, for a total of $7,264.53.
Mr. Jones, is that $7,100 the past due rent? Is that accurate, sir?
I think mine is $675 because $775 because I paid my February rent, but for some reason they say I didn't. I paid it to the previous owner. The new owner took over. They had I just need a chance for these people to pay. They said it paid 12 months. They tried. I got emails saying they were going to pay it August 1st, but they couldn't get in touch with no rental office. The rental office wouldn't get back with the people to pay it. They were going to pay it up because the sheriff didn't pay it up. The same lady said, well, there's another program that can help you. And then we went through the paperwork, kept calling the Bill's property. Bill's property didn't get back with them. So then they denied me. But they just sent me an email yesterday actually, on the 7th. They sent me 6th. They sent me one yesterday. There's a new program, the HRA program, and they were gonna help me out. I don't
Mr.
know.
Graham Mason, how do you want to proceed, sir?
They give me to the end of the month I could probably make sure that they get with them. I wanted to ask if the court or the Bill's property would they would accept me paying my rent and half a month's rent each month to catch back up. Because I thought Sarah was paying, then I got behind and I couldn't pay it. Once was behind 4,000 or 5,000, I couldn't pay it. So then the other program, that's been 2 more months. I work every day. I've been here 2 years. 3 years now.
Mr. Graham Mason, how do you want to proceed, sir?
I would like to proceed to seek a judgment based on the stay being lifted and the hearing having been today. There's been no denial that the rent is owed, so there are no triable issues of fact based upon what I've heard thus far. As far as the name is concerned, it's all other occupants along with that particular address. It is one letter off, and
I got emails from the people saying that you guys didn't get with them, man. They asked me, did I get in touch with you? I couldn't get in touch with you. I went to the office at Ypsilanti. I stay in Romulus. I went to the office 2 or 3 times. No one was never there. No one never answered my call back. The company was, all they needed was you guys. They were just like Sarah. All they needed was you guys to get back with them. And actually, I'm asking for give me 2 weeks to try to get them to pay you guys before you just judge me out of here.
Well, Mr. Jones, it's not as simple as they just get you out of there. And Mr. Graham Mason was starting to ask the court to enter the judgment. And in as much as you admit that rent is past due and owing, the plaintiff is entitled to entry of judgment. By statute, they have to allow 10 days for you to pay or vacate. Mr. Graham Mason, is your client flexible in that writ date?
We've provided a writ date of September the 19th, which is 12 days, which allows for the weekend. That's more than what's required by the law. However, if the court requires a longer writ date, then we would accept that.
I do have emails, Your Honor, showing that they have tried to get in touch with these people, asking me, have I got in touch with them? And then telling me that I was denied because they can't get in touch with them. And then you just said Kevin Jones, and that's why they couldn't get in touch with him.
I understand that, Mr. Jones, and that's why what I was doing was looking on the lease that actually has your name correct. So I'm not sure why plaintiff filed improperly, but the lease is written in the name of Kelvin Jones. And Mr. Graham Mason, this court does not typically force apartment complexes, landlords to go beyond the statutory 10 days. But based on the fact that Mr. Jones' testimony this afternoon is that the agency tried to get your client's cooperation in processing the Sarah application and could not because of the lack of response. And he's now made application through another program at Wayne Metro. The September 19th date is 10 days with the 10 days falling on the weekend. So that's not any being magnanimous in 10 days. Mr. Jones, the court will go just 2 weeks from today. Since you said you needed 2 weeks, that writ date will be September 21st. What will happen now, sir, is that Mr. Graham Mason's office will submit a judgment to the court with rent of $7,100, court costs of $164.53 for a total of $7,264.53. It will indicate that you need to pay or move by September 21st. Once that is submitted to the court and is signed, a copy will be mailed to you. I would suggest that you take a copy of that judgment, be in touch with Wayne Metro and let them know that you are now facing eviction. That might help in getting your application processed more quickly. And I asked you not to smoke while we were in court.
I'm not
You would not smoke
smoking.
inside of
It's not burning. Sorry.
That's
But,
okay. Anything else, Mr. Graham Mason?
Nothing further, Your Honor.
I got one more.
Anything else, Mr. Jones?
Yes. So on the 21st, if I don't have them paid, someone to come put me out of here, or? how
No,
does that
sir.
go?
No, sir. Your Bill Properties would have to come back to the court and file an application requesting the order to have you removed. It's not instantaneous. The plaintiff
Okay.
still has to file additional paperwork, sir.
Okay, so I can hit the lottery and still pay them or something if anything happens.
If you hit the lottery, we'll have a different conversation.
Okay, thank you. Thank you, Mr. Bill Property too.
Have a good
Even-
afternoon, Mr. Jones.
Yes.
This is 222599 LT. This is Trilogy versus Mushta, Amtala Samud, and Dejan Fields.
It's Mashta, Matula, Samad, and Dejan Fields. We're both here.
Which one are you, sir?
I'm Dejan Fields and Mashta in the camera.
And I'm here. I'm here as well.
No, I'm not. I'm here. It's not sufficient. I need you to state your name for me, please.
Oh, Mashta Amatullah Samad.
Thank you so very much. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place since June 15th. 84 days have passed. Mr. Fields, has your Sarah application been approved?
It was
Well, we did a recertification, and that has not been approved yet. But the original Sarah application, was approved. By the time we got our check from Sarah, we went to Trilogy offices to pay our rent due. And we were told that we would have to like download the app, pay it online. And then when we tried to pay it, it didn't go through. And they told us that since we were behind, the only way we could pay it was through a cashier's check. And yeah, that's what they told us. And so by the time, so I had to wait a few days because my bank is online, I bank with Discover. And by the time we got our cashier's check, it was already the next month due. So they wouldn't accept the check because it was only a partial payment of the total amount owed. And now since it's September, we're planning on, we have to get out of here anyways. So they didn't accept the money when we tried to pay them. I tried to ask them to take it through ACH transfer. We also asked them, could we do money orders? We tried to pay it online. We tried to pay it through the app, pay by phone. They didn't accept it anytime.
Raise your right hands for me, please. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Graham Mason, how much rent is due to retain possession in this matter?
At this time, the rent to retain possession is $7,839.77. The cost for service, filing, and for attorney's fees is $199.14. So the total amount is $8,038.91.
So how much was this Sarah money that you received that your landlord would not accept?
It was about 3,600. And at that time, that was in June, I believe. So when we got the check, it was enough to cover the entire portion that we owed.
right. They accepted partial. So when we first did the application, they accepted partial payment. So when we first did our Sarah application and it was approved, we was approved for $10,000
Yeah.
to pay the whole entirety. Once we only had received $6,500 from Sarah. And Sarah called Trilogy, and can you hear me?
I have to interrupt you for one moment.
Yes.
She said that she received $3,600 and now you're saying you received $6,500.
That is the second payment.
Okay.
So the first Sarah payment we received, we was approved for $10,000. And the email was sent to us and Trilogy Apartment. When we first got our first Sarah check, it was only for $6,500, which did not cover the entire $7,000 we needed to pay Trilogy. At that time, Sarah emailed Trilogy and was asking them, can we pay partially until we receive the rest of the money we was approved for? Even with that, we did pay the $6,500 to Trilogy. Afterwards, which we was waiting for the rest of the payment, rent was still due and rent was still going up. So we had delays with Sarah because they did not believe we paid Trilogy, which we showed them proof and everything. Then when we finally did get the $3,500, they would not accept it because we was already over $3,500 in rent due. So
You
that's
heard the
when,
attorney, I'm sorry, sir. Did you hear the attorney indicate that there's $7,839?
yes, the 7,000 now from June. The last,
Please don't interrupt me.
yes,
You heard him say that that's the amount that's due and owing in rent, correct?
right,
Is that the correct amount of rent?
yes,
Do you still have the $3,500?
yes.
Do you have any defense to the non-payment of rent case?
Yes,
What's your defense?
we have emails. We have emails from Sarah. She's asking for our defense on the. Well, can you clarify, please, Miss, what you mean by defense for me and my?
It's not Mrs. Judge.
Oh,
The
Judge,
plaintiff's
I'm
attorney
sorry.
has said that there's $7,839.77 in rent due and owing. The
Right.
defense would be, no, that's not right. We paid 2,000. It's only 5,800. That's the defense. If there's a reason why $7,800 is not due to Trilogy is my question.
Yeah, so it is that. It is that. That is correct. But that is from the partial payment. So when we partially did. Yeah, that is what we are.
No, if you're gonna repeat what she says, just let her talk. There's 16 other people waiting to have their
Right.
cases heard. So if there's somebody available to respond to my question, is $7,839.77 in rent due and owing?
Yes, that's correct.
Okay. In as much as you acknowledge that that is the amount of rent that is due and owing, the court has already lifted the Sarah stay. Once you admit that that is the amount of rent that is due and owing, there remains no triable issue and plaintiff is entitled to entry of judgment. Mr. Graham Mason's office will submit a judgment to this court that sets out that amount, $7,839.77. There's cost of $199.14 for a total judgment of $8,038.91. Mr. Graham Mason's office will send that to the court electronically. The court will sign it and a copy will be mailed to you, and it will say that you need to pay this amount or move by September the 19th. If you try to pay in response to that judgment and your landlord refuses to accept it, Mr. Graham Mason will have to have a different type of conversation with this court. I can't imagine why a landlord would refuse to accept money when they say that money is due to them. Those two things can't go together. And if someone tries to tender money and you refuse to accept it, that's a different conversation.
Thank you, Your Honor.
I'm sorry, anything else, Mr. Graham Mason?
No, Your Honor, I was going to ask when the writ date was going to ensue because of any extenuating circumstances, but you already answered that for me, and I have one more case.
Anything else, Mr. Fields?
Yeah, right there. What you
No.
want to say? No,
And
that'll
that
be all,
concludes
Miss.
this matter. We're all set. You all have a wonderful afternoon.
Okay, thank you.
Thank you. Is it 222556 LT West Village versus Marnique Gibbons and Kendra Bascom? No, that's Mr.
Kendra
Lemon.
is here.
I'm sorry,
Marnique.
Mr. Lemon, give me 1 second. Mr. Graham Mason, what's the last case you had?
It's Huron Estates and Davis.
222308 LT Huron Estates versus Rebecca Davis. Huron Estates versus Rebecca Davis. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now for 82 days. Notice was mailed to the defendant to appear this afternoon at 1 o'clock. It's now 1:23 by this court's clock. Mr. Graham Mason, the court notes your appearance for the record. Defendant having failed to appear, how would you like to proceed, sir?
We would like to proceed towards a default judgment for possession, rent to retain possession in the amount of $3,856, cost in the amount of $164.53 for a total judgment of $4,020.53 with the writ to issue on the 19th of September.
Thank you, sir. Based on the defendant's failure to appear in this matter, the Sarah stay previously entered is hereby lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,856, $164.53 in cost for a total judgment of $4,020.53. Writ date of September 19th, 2022. Plaintiff's office to submit that judgment for entry. Anything else, Mr. Graham Mesa?
Nothing further, Your Honor. Thank you and have a good afternoon.
Thank you, sir. You as well. This is 221470 LT. This is GI 9 Harbor Club versus Breon Gaston. Maybe not. This is 222542 LT. This is West Village Estates versus Bruce Jones.
Good afternoon, Your Honor. Daniel Landman, P35797, on behalf of the plaintiff.
Bruce Jones or anyone at 6947 Carson Drive, number 370 in Romulus. Mike Jones and Bruce Jones.
Hello, good afternoon.
Can you turn your video on, please, and state your name for the record?
Yep, I apologize. Good afternoon, this is Michael Jones speaking.
I'm sorry?
Good afternoon, this is Michael Jones speaking.
Michael Jones, thank you, sir. Mr. Jones, are you an occupant at the 6947 Carson Drive address?
Yes, I am.
Today is the day and time set for hearing on, oh, sorry, where's Mr. Bruce Jones?
He had recently, not recently, I apologize. He had moved out some years back, actually, down to Indiana.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay that has been in place now for 84 days. Mr. Jones, has your Sarah funding been approved?
According to my knowledge, no, not at this time. I believe it's still pending. I've been trying to contact Sarah for the longest time. I have not had any luck with that. I will continue to do so, or if the best course of action would be to try to get, to reapply, then I will most certainly do that as well.
Mr. Jones, raise your right hand for me, please. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Lamon, how much rent is due and owing in this matter?
Your Honor, current rent to retain is $2,992.54. Costs are $164.57 for a total of $3,157.11, and that does include September's rent.
Thank you. Mr. Jones, is $2,992.54 in rent due and owing?
Yes.
Sir, inasmuch as more than 45 days have passed and Sarah funding has not paid the past due rent, this court is required to lift the Sarah stay and will do that. Inasmuch as you acknowledge and admit that the amount of rent set forth by the plaintiff, $2,992.54 is due and owing, there is no dispute as to their rent. There remains no triable issue. Plaintiff is entitled to entry of judgment as paid, including $164.57 in court costs for a total judgment of $3,107.11. Plaintiff's office will submit that judgment in that amount. Once you receive it, sir, I would suggest that you be in touch with the agency that you made your Sarah application to in the hopes that that expedites the processing of the application that's been pending now for almost 3 months, okay?
Will do, thank you.
Anything else in this matter, Mr. Lamon?
No, Your Honor.
Anything else, Mr. Jones?
Not at this time, no. Thank you, though.
Thank you, sir. Have a good afternoon.
Thank you, you as well. Bye-bye.
Thank you. This is 222551 LT. This is West Village Estates versus Kalisha Weems.
Daniel Landman for the plaintiff.
Yes, I'm on.
State your name, please.
Kalisha Weems.
Thank you so much. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place for 84 days. Ms. Weems, has your Sarah application been approved?
So I got an email from them last week saying that they're working on my application.
So the answer to the question is no, it has not been approved?
No, it has not been approved yet.
Okay. Ma'am, raise your right hand for me. Do you swear from testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes,
Inasmuch as more than 45 days have passed since the Sarah stay went into place in this court, the court is required to lift the stay and will enter indication in the file that that stay has been lifted. Mr. Lamon, what is the rent to retain possession in this matter?
Your Honor, inclusive of September's rent, the rent to retain is $7,115.86. Costs are $164.57, resulting in a total of $7,280.43.
Ms. Weems, has Mr. Lamon accurately stated that the rent due and owing at this time is $7,115.86?
I'm not 100% sure if that's the right amount. That's not what I got when I added it up, but I could be wrong. I'm not 100% about 7,000 because June, May, June, July, maybe. I'll say yes because I'm not sure.
Okay. Ms. Weems, inasmuch as you acknowledge that there is no dispute as to their rent claim due and owing by the plaintiff, there remains no triable issue of fact, and the plaintiff is entitled to entry of judgment in that amount of $7,115.86 in rent, rent to retain possession, $164.57 in cost. That'd be a total judgment of $7,280.43.
Mhm.
Mr.
So it's
Lamon,
$7,280. I'm sorry, I didn't get that amount. Let me write, I wanted to write that down.
$7,280.43.
Okay.
Okay, Mr. Lamon's office will submit it to the court for entry. It will sign it. A copy will be mailed to you. Submit it to the Sarah agency. Let them know that you're facing eviction. Maybe that will help to expedite the processing of your application, okay? Anything else in
Okay.
this matter, Mr. Lamon?
No, Your Honor.
Anything else, Ms. Weems?
Yes. How long do I have?
The judgment will indicate that you need to pay or move by September 19th.
Okay.
Thank you, ma'am. Have a good afternoon.
You too. Thank you.
Thank you. This is 222556 LT. This is West Village Estates versus Marnique Gibbons and Kendra Bascom.
Daniel Landman for the plaintiff.
My apologies.
Yes, ma'am.
Oh, no, I was saying that Kendra Bascom here on behalf of the case. Marnique Gibbons is not here. He's at work.
She's where?
He is at work.
He is at work. Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. That stay has been in place for 84 days now. Ms. Bascom, has your Sarah application been approved?
I just got verbal confirmation at 12:56 when they called me getting into this courtroom that they were approving me and that they were reaching out to West Village in the process as well.
They called you, but have they sent a confirming email at this point?
I have no idea. I've been in this Zoom chat, so I haven't been able to check my email. But I know that they said that they were reaching out to West Village when I got off the phone with them.
I see a representative here from West Village. If she's received an email or a phone call, I'm sure she'll indicate as much to the court. Ms.
Okay.
Bascom, raise your right hand for me, please. Do you swear from the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Lamb, and the rent to retain possession in this case is?
Inclusive of September's rent, $6,541.53. Costs are $199.14. The total is $6,740.67. That does not take into consideration, obviously, Your Honor, the potential Sarah payment.
Ms. Bascom, do you admit
Also-
and acknowledge that $6,541.53 in rent is due and owing?
Yes. Also, I'm sorry. I said, yes, ma'am, that is correct. But I also wanted to let you all know that I reached out because Sarah hadn't got back with me before this court date. I didn't know if they were going to. I also reached out to my DHS worker, and he said that they would also participate in helping to pay the rent. But Sarah had to pay theirs first. Hi. Are you still there? I see somebody else.
I'm here, ma'am.
Oh.
That was somebody else. I've shut off their sound now. Thank you for that update regarding DHS involvement, ma'am.
Okay.
But in as much as you acknowledge that that is the rent that is due and owing $6,541.53, plaintiff is entitled to entry of judgment in that amount with cost of $199.14 for a total judgment of $6,740.67. Mr. Lamon's office will submit a judgment to the court electronically. The court will sign it. A copy will be mailed out to you. As I've indicated in previous hearings, you should take a copy of the judgment once you receive it, and that's what you should submit to DHS and to the Sarah agency to expedite the processing and the release of funds to you to cover this past due rent, okay?
Okay.
Anything else, Mr. Lamon?
No, Your
Anything else, ma'am?
No, I was trying to see if I seen Renee in here earlier. I was gonna ask, did they reach out to her? But she
Sarah
hasn't.
just called a few minutes ago. They didn't say anything about you being approved. They asked for a copy of your lease and ledger.
Okay.
It's
Thank
been
I'm
sent to
sure
them.
Ms. Samples will provide that.
Oh, we did already. Thank you.
Oh, Ms. Samples, thank you so very much. Okay, Ms. Bascom,
Thank you.
good luck to you, ma'am. Have a wonderful afternoon.
You too.
Thank you.
Bye-bye.
This is 222553 LT. This is West Village Estates versus Jerusha Williams.
Daniel Landman for the plaintiff. Williams.
Ma'am, your name for the record?
Jerusha Williams.
Thank you, ma'am. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now for 77 days. Ms. Williams, have you been approved for Sarah funding?
No, ma'am. They sent me a email. I'm sorry, I can tell you the date. They sent me an email a week or so ago acknowledging that it's being denied due to lack of contact from, one second, I'm so sorry, I was trying to get it pulled up in time. August 21st, they sent me a denial due to attempt to contact tenant and landlord for 30 days and no response.
Attempted contact with you or contact with West Village? I'm sorry.
Both. I responded to their email right away because I had never received the email or anything from them. But the email states both.
Ms. Williams, raise your right hand for me, ma'am. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Lamb, the rent to retain possession in this case is?
Your Honor, inclusive of September's rent, the rent to retain is $3,052.40. Costs are $164.57, resulting in a total of $3,216.97.
97 cents?
Yes,
Okay.
3,052.40 plus 164.57 for a total of 3,216.97.
Thank you. Ms. Williams, is $3,052.40 in rent what is due and owing in this matter?
Yes, ma'am.
Ma'am, inasmuch as you admit and acknowledge that you have not received your SARA funding, this court is required to lift the SARA stay and will make that notation in the file. Additionally, inasmuch as you admit that $3,052.40 is the rent due and owing, there remains no tribal issue of fact in this landlord-tenant non-payment of rent case, and plaintiff is entitled to entry of judgment in that amount. Mr. Lamb's office will submit that judgment to the court electronically. The court will sign it, and a copy will be mailed to you. I don't know if you intend to follow up with the SARA or make application to some other agency for financial assistance. There will be a writ date of September the 19th where you need to either pay or move from the property by that date. Anything else, Mr. Lamb?
No, Your Honor.
Anything else, Ms. Williams?
No, ma'am.
Thank you so very much, ma'am. Have a good afternoon.
You as well. Thank you.
Thank you. This is 222481LT. This is Pinewood Circle versus Narkita Gray.
Good morning, Your Honor.
Good afternoon.
Sorry,
ma'am. Your
good
name for the
afternoon.
record, please.
Narkita Gray.
Thank you, Ms. Gray. I know that I saw Mr. Katz at some point.
Yeah, he is, Judge, he's in
He's
a
in a
breakout
breakout.
room. Yeah.
He's in a breakup. Ma'am, have you had a chance to speak to him?
No, ma'am.
Okay.
No, Judge, I'm sorry.
No, you're fine. Thank you. I was being a little snarky earlier. It's okay. Let's see if we can get him out so we can figure out what's going on. Sit tight for one moment. Let's see. Ma'am, your name in that either dark blue or black t-shirt?
Yes, Precious Cole.
Ms. Cole, thank you.
You're welcome.
We saw you this morning. Thank you for getting back on timely. Have you spoken to anyone from West Village as of yet?
No.
This is 222538LT. This is West Village Estates versus Cole.
Daniel Landman for the plaintiff, Your Honor.
Today is the day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place for 77 days now. Ms. Cole, has your SARA application been approved?
No, it wasn't, but I applied for EREP and that one was approved, but they still haven't sent any payment out. I haven't received anything, and clearly the rent office haven't received anything either. I
Ms.
keep
Cole, raise your-
calling. Oh, I'm sorry.
I'm sorry, go ahead, finish.
I keep calling. The last time I called was last week, and they said that they're sending out some pay card, but I haven't received anything as of now. And like I said, I don't think they have either. So I don't know. I'm just asking for just a few weeks so I can just get the balance down, because I don't know if they're gonna send it out or not. But I would like to just have a little bit more time, and I'll just pay it off.
How much was your ERAP card supposed to be? Do you recall?
And I don't know. They just sent me an email saying that I was approved. And that's all I ever heard from them. And like I said, when I called, they say that I'm waiting on a pay card. The judge, I think it went in as 17 something. And then, like I said, I don't know, anything after that.
Ms. Cole, raise your right hand.
Oh.
Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Lamon, what's the rent to retain possession in this matter?
Your Honor, based on my client's books and records and including September's rent, the rent to retain is $3,918.31. Costs are $164.57. The total is $4,082.88.
Ms. Cole, do you admit and agree that $3,918.31 in rent is due and owing?
Yes, I do.
Ma'am, inasmuch as you acknowledge to this court that your application for financial assistance remains outstanding more than 45 days after entry of the stay, this court is required to lift the stay and will make a notation in the file that that has been done. Secondly, inasmuch as you admit and acknowledge that $3,918.31 in rent is due and owing, and that is the amount that's been requested by the by the plaintiff in this matter, there remains no triable issue and the plaintiff is entitled to entry of judgment in that amount, plus court costs of $164.57 for a total judgment of $4,082.88. Mr. Lamon's office will submit a judgment to the court which indicates that that is the amount that's due and owing. I would suggest, Ms. Cole, that after you receive a copy of that judgment, that you follow up with ERAP and make whatever other arrangements you need to make to pay that balance, the difference between what the ERAP pay card award was and the outstanding rent. Anything else in this matter, Mr. Lamon?
No, Your Honor.
I have a
Anything else?
question. For how long?
Yes, ma'am.
I'm sorry. So how long do I have to pay, how long until the judgment says, I have to get out? Like, what's that date?
It'll say September the 19th is your pay or move date, but if September 19th comes, it's not like West Village Estates just shows up at the property. Mr. Lamon's office would have to come back and make an application to the court asking for an order to have you physically removed.
Okay.
So that gives you a little bit of time to follow up with that ERAP card and make payments on your own if you're able to.
Right. Okay. Thank you very much.
You're so very welcome. Thank you. I appreciate you from logging on this morning. Have a good afternoon.
Oh, you're welcome. You do the same. Bye-bye.
Thank you. Oh. This is 222559 LT. This is West Village Estates versus Christine Delong and David Delong.
Daniel Landman for the plaintiff, Your Honor.
State your names for the record, please.
David DeLong.
Christine DeLong.
Thank you. Today is the day and time set for hearing on plans requested with the Sarah stay that's been in place now for 77 days. Mr. DeLong, Ms. DeLong, has your application for Sarah funding been approved?
My half application was approved, but Renee refused to become a partner with the plan and gave me some phone numbers that didn't go to anybody at Sun Communities.
Wait,
So-
I'm sorry, sir. Wait. Say that again.
The park refused to partner up with the state funding. So our power got shut off on April 15th or August 15th. And we had to go forward with the funds. So our house is paid for and our power is paid for, but they refused it.
So your Sarah funding was approved and they
Yeah.
mailed the payment to you?
No, they don't do it that way.
Oh.
You have to sign up a 2-page thing online and partner with them. Renee refused to do it and didn't give me a phone number to anybody I could contact that would be able to do it for Sun Communities.
That's not my understanding of the Sarah program, Your Honor. Our client may not participate in the Sarah program, but the funds would still be sent directly to the tenant.
No, this is my half.
No, it's through my half.
We're not approved for anything through the DHS. So we went through another program through Wayne County Community Action Center. And they signed us up for this one, which we were approved, and I couldn't get a phone number to anybody that would sign the paperwork. They told me there's thousands of people waiting for Sun Communities to sign up.
Could you please raise your right hands for me? Do you swear from testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Samples, what were you starting to say?
Your Honor, my company doesn't participate in them programs, but they do have them send the people the money and them pay us. And I, of course, gave them the number to the main office that you can find online, but they are not participating in any of them programs. Not his, not Sierra, not the ERAP. They have to, we will give the lease and ledger and they send the money to the tenants and the tenants get us a certified check or money orders to pay it.
I've forwarded every email to Renee as well, saying that they had to sign up with a 2-page thing online.
My boss will not allow me, Your Honor. Their son is not partaking in these programs, so we are not permitted to sign up for anything.
Mr. DeLong, I am not familiar with the MyHalf program or the requirements thereof. I know that most of these funding arms since COVID have pivoted to allow tenants to apply and have payments made directly to them to get around reluctant landlords. I hear what you're saying though regarding your emails.
I have all the emails and they've all been forwarded to Renee. She's well aware of it. But I've tried calling
What
that
she's
phone
saying
number.
now is. Go
The
ahead,
phone
sir.
number, the phone number that she gave me, I've called them about 15 times because we had a busted water main in our yard for a year and a half, which is still not fully repaired yet.
And they never answer the phone.
They never answered the phone one time on the
They don't
hotline
call
for
you
some
back?
communities.
They
Not
don't-
one person's ever called me back in a year and a half.
There's no help.
Ms. Samples, are you aware of this repair issue?
Yes, Your Honor, they came out and fixed it. It was from a water meter from his next door neighbor. They came out and fixed it. It's not leaking. I've been checking to make sure there's no water. He has not called in any recent problems with it. And he also was talking to the contractor that was working on that project. They have each other's number. He was keeping him posted.
Mr. Lamb, what is the rent to retain possession in this matter?
Including September's rent, Your Honor, the rent to retain is $3,765.54. Costs are $199.14, resulting in a total of $3,964.68.
And Mr. Lamb, it's your understanding that your client does not participate, does not complete applications and participate in rental assistance programs? Am I understanding that correctly?
Your Honor, I was certainly aware that my client did not participate in the SIRA program all the way through. What occurred for the tenants that were behind and had submitted SIRA applications in accordance with the SIRA program was that the tenants would receive the SIRA money directly, and they would then turn around and pay my client, and that arrangement seemed to work perfectly well. I don't know what the story is with ERAP and MyHap. Things are not quite as fully fleshed out at this time, but I'm astonished that the money would not be paid to the tenants if the tenants need assistance. That just simply makes no sense to me. I know of nothing that requires a landlord, any landlord, to participate in the program in order to get paid.
Your Honor, with ERAP, the people have been coming in, they are given a card. They've been going to the bank, getting the cash out and getting money orders. They have not had any problems with ERAP either.
Ms. Samples, I hear that and I understand what you're saying, but when you have Mr. DeLong indicating to this court that there are emails that specifically ask for the plaintiff to submit, I believe he said a 2-page application so that funding may be, financial assistance may be provided to tenants. The court has some concerns about the
I-
tenant's refusal?
I contacted my boss and asked her, sent the emails that he sent me, confirming that we do not participate in any of them, explain the situation. And she said, Sun Communities does not participate in any of these programs. I cannot fill out an application. I cannot sign anything, and I cannot send our W-9.
So, Mr. Lamb, your client is refusing to participate and accept payments towards the rent. Okay.
Your Honor, I think, I would say the first half of that is correct. I think they're very happy to accept payments if tendered by the tenant. I suppose in order to really get to the bottom of this, I would need to see the emails and talk to the people who sent the emails to see why there's a disconnect with entities that are not participating in the program. Because I am unaware of any requirement that the landlord has to participate in order to get paid. This is the first time in all of the courts that our office represents landlords in that I'm hearing anything to this effect.
It's the first time that I've heard it as well, Mr. Lamb, and it causes me concern. I know that we had put some things over to next Wednesday afternoon, September the 14th in the afternoon. I think the last thing we scheduled, Mary Ann, was at 2 o'clock. Mr. And Mr. Long, are you available on September the 14th at 2:30?
Be at work. Figure something out.
Can I add something? I tried calling their office too, because their office was representing Triad Financial, which owns our house. And they didn't call me back as well,
The attorney.
the attorney's office, because they were representing them, which those people partnered and they got paid. That's the other person that he was representing.
Mr. DeLong, I'm using the chat function to send you my email address. If you can
Okay.
forward the emails that you received that indicate that it's mandatory for the landlord to participate, I will call and follow up with the caseworker.
That's good, great and grand, but I called every single day and spoke with Renee's
Mr.
office
DeLong, no.
for 2
no,
weeks.
Let's fix it from here forward. Ms. DeLong has already
There's a problem,
indicated that
though.
she's not.
Stop. Just relax.
They already paid the funds
Okay. Yeah.
because they waited too long.
They're not gonna do it again, but have to find another program. I don't know.
So the funds were actually paid over to the DeLongs and they used it for other purposes, is what I'm hearing.
No, these
No,
people were
they don't.
partners and they got paid because this electronic transfers, it never touched us.
Okay,
Different kind
so,
of program.
so you haven't received money.
No.
No,
No.
the
Okay.
payments got made to the companies directly. That's why that works that way.
I want to follow up on.
Yep.
The woman that we spoke to, she's the one that contacted DT and Triad directly, and the funds get dispersed to them. We never got anything.
Your Honor, I've put on the chat my email address, and if the DeLongs can provide me with the emails from that particular representative, I will follow up as an officer of the court and see if I can get some kind of explanation, which it sounds like will not only benefit me, but may benefit the court as well.
I saw your chat, Mr. DeLong, I'm sorry, Mr. Lamon, and what the court was trying to do is schedule a time for the parties to come back and give the DeLongs the opportunity to present that information both to you and to the court. But when I'm interrupted, it's very difficult for me to schedule over people speaking over me. So I stopped talking to allow you all to continue to talk. My question was availability next Wednesday. Ms. DeLong indicated that she has to work. So let's look at some different dates. Mary Ann,
Yes, ma'am.
the 21st. Well, let's do it a different way. When are you available, Mr. and Mrs. DeLong?
I do the 13th.
Is any day of the week better than another day is my question.
Can we do September 13th, Tuesday? Or would it have to be on a Wednesday?
Landlord tenant day is on Wednesday for me, but that's not a deal breaker. I'm looking at the 13th right now, Mary Ann. I don't see anything scheduled that day for us at all. Mr. Lamon, is your office or somebody available from your office?
I'm sure we can have somebody available, Your Honor.
Morning or afternoon, ma'am?
Morning is fine.
We will have a Zoom hearing on this matter next Tuesday morning, September the 13th, 2022, 8:30 a.m. for courtroom number 1. Any documents that you want the court to consider during the course of that hearing should be submitted to the court from the court's website. There's a function on the first page that allows you to contact us and submit the proofs. If you want to send copies of the emails that you indicate show that the West Village is refusing to cooperate, that is how you submit them to the court. It is very difficult and time consuming to screen share and try to review documents during the course of the hearing. So if Mr. Lamon has things he wants the court to review, he will submit them. The Delongs will similarly go to the court's website and submit the proofs. You'll need to include the case number, and you can submit all of the documents that you want the court to consider during the course of the hearing on the 13th. Anything else, Mr. Lamon?
Your Honor, I just want to clarify, is that by Zoom on the 13th or in person?
By Zoom, unless you want to appear, sir.
No, I was concerned because you mentioned courtroom 1 and I didn't know if that meant that we were required to appear there.
I don't require people unless they want to appear. If the Delongs want to appear in person, or are you satisfied with the Zoom hearing?
Zoom is fine.
Bring
This is the
paperwork.
only thing that's scheduled for me on the 13th, so we will start promptly at 8:30. Again, please submit what it is you want me to review. Other than that, we're all set in this matter. Have a good afternoon.
Thank you, Your Honor. You as well.
Thank you.
Did you get this?
Oh, Pallett's office. Pallett's office, 221740 LT. This is GI 9 Harbor Club versus Breon Gaston.
Turning on my video, Your Honor. Daniel Marchese, P75872 plaintiff.
Mr. Marchese, this is the second time that I've called this case now. I have not heard a response from Gaston. This case was scheduled at 1 o'clock. It is now 2:01 p.m. by the court's clock. Defendant having failed to appear, sir, how do you wish to proceed?
Your Honor, my sincere apologies. I thought it was taken care of, but we should have submitted a dismissal in this matter.
There is not one in the court file. Would you double check with your staff and make sure that it has been submitted? If not, you may send one by email to the civil department. They'll get it upstairs and get it processed, sir.
I will do that today, Your Honor.
Thank you, sir.
Thank you.
I know you have a 2 o'clock case, but there's some 1:30s outstanding. So if you sit tight, let me get Mr. Katz's cases called.
No problem.
This is 222481 LT. This is Pinewood Circle versus Gray.
Good afternoon, Judge.
Good afternoon, Your Honor. Sidney Katz on behalf of the plaintiff.
Ms. Gray, state your name for me, please.
Narkita Gray.
Thank you. Today is a day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place now for 77 days. Ms. Gray, has your SARA funding been approved?
No, ma'am. The second tier was not approved.
Raise your right hand for me, ma'am. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Ma'am, in as much as more than 45 days have passed since the SARA stay and it's not been approved, this court is required to lift the stay and will do so at this time. Mr. Katz, what is the rent to retain possession in this matter?
Your Honor, we did enter into consent judgment at this time. I
Oh.
did speak with, yep, on the 3 of mine that are here, I do have consents, just so we can cut to the chase on all 3. Your Honor, currently there is a balance of $4,515 of past due rent, $165 of costs for a total of $4,680. Ms. Gray understands she has until September 19th to pay that amount, to move out or work something out with my client. If none of those happen, she's aware of a writ may issue. She was advised of MCR 4.201 and did authorize me to submit this to the court with her verbal authority.
Ms. Gray, were you able to hear Mr. Cash just now?
Yes, Your Honor.
And ma'am, you agree that a total of $4,680 is due in rent and court costs?
No, Your Honor. I believe, was it 4,516 or 4,600?
It was 4,515 for rent, 165 for court costs, for a total of $4,680.
Yes, Your Honor.
And that, ma'am, that's what you wish to agree to.
Yes, Your Honor.
And because you're on Zoom, there is not a signed consent judgment. Are you authorizing Mr. Katz to sign your name to the consent judgment?
Yes, Your Honor.
And Mr. Katz also explained that because Pinewood Circle is represented by an attorney and you are appearing in pro per, that judgment will not be final and enforceable for 3 days. Did he explain that to you, ma'am?
No, Your Honor.
I did, just a different way, Your Honor. I indicated that
I'm
she has
sorry.
3 days to appeal a consent judgment.
Is that what he
Yes.
explained to you, ma'am?
Yes, Your Honor.
Ma'am, inasmuch as that is what you wish to agree to, Mr. Katz's office will submit the consent judgment to this court for entry. He will submit it by email. It will come to me. I will sign it, then a copy will come out to you in the mail. Anything else, Ms. Gray?
No, Your Honor.
Thank you so much, ma'am. Have a wonderful afternoon, okay?
You too as well.
Thank you. This is 222480 LT. This is Pinewood Circle versus Derek Radford.
Good afternoon, Your Honor.
Mr.
Sidney
Katz,
Katz.
the
on
court
behalf-
notes your appearance for the record. Mr. Radford, state your name for me, please, sir.
Good afternoon. My name is Derek Radford.
Thank you, sir. Mr. Katz has already indicated that there is a consent judgment in this matter. What are the terms, Mr. Katz?
Your Honor, there's currently a balance due of $6,487 of past due rent, 165 of costs for a total of $6,652. Mr. Radford understands he's got until September 19th, and he was advised of MCR 4.201 and did authorize me to submit this to the court with his verbal authority.
Mr. Radford, we're actually here this afternoon for hearing on plans requested with the Sarah stay that it's been in place now for 77 days. Sir, what is the status of your Sarah application?
It was approved, and I did make a payment to my landlord for $3,450 on August the 24th.
And sir, after this payment of $3,450, is $6,487 in rent remain due and owing?
Yes, ma'am. And I've been in direct contact with my apartment manager and let them know my intent on paying it. I've also signed up with another round of funding that was available through Wayne Metro. It's called the Home Rental Assistance Program. I was pre-approved with that through my email, so I'm just waiting diligently. They told me to call them back in a couple of weeks. They should have more funding and more program information towards that. And go ahead. I'm sorry.
I'm sorry, Mr. Radford, you heard Mr. Katz say that you have an agreement with him that $6,487 in rent is due and owing, $165 in cost for a total judgment of $6,652.
Yes, ma'am.
And sir, because you're appearing by Zoom, there is not a signed consent judgment. You're authorizing Mr. Katz to sign that judgment on your behalf?
Yes.
And he further explained to you that you have 3 days before that judgment is final and enforceable. You could come back and tell the court that that is not that the consent judgment does not accurately reflect what the parties agreed to?
Yes, ma'am.
Mr. Katz's office will submit that consent judgment to the court. The court clerks will bring it upstairs. I'll sign it and the copy will go out to you in the mail. Did you have some other question or statement that I interrupted you from?
I did. I just wanted to know, I know I have to the 19th to pay, but I was asking if it's possible I can ask the court for an extension because I won't have that on the 19th. I'm gonna try my best, but I was hoping I can have an extension to get it taken care of. I'm going to work out. Mr. Katz let me know that he will be in agreement if I work out something personal with the apartment manager themselves. He would be in agreement with that. So I was just making sure, is that okay with the court once I go and talk with the apartment manager?
Mr. Radford, respectfully, the court doesn't care how the parties work it out. What'll happen is the judgment will say that you must pay or move by September 19th. If you're in direct communication with your landlord and you reach some separate agreement, they'll relay that to Mr. Katz and he won't take any additional action so long
Okay.
as you're current in whatever agreement is you reach with the management office, okay?
Okay.
And Your Honor, I always advise them that if there is an agreement, it should be in writing. This way, there's clear understanding.
Understandable.
And writing doesn't have to be a formal thing, Mr. Radford. It can be email confirmation, text confirmation, something so that your position is protected. Understood?
Awesome. Awesome. So I can write an email, and as long now, Mr. Katz, well, if we agree upon our own arrangements, just forward those emails over to you, or
Nope. They will let me know. I will request, information on the update of your case. And if
Okay.
you have an agreement with them, they'll tell me to hold off. Okay?
Okay. Okay, awesome.
All right. Okay.
Thank you.
Oh, just so you
Thank you,
know,
Mr.
if you send them an email, in order for it to be an effective agreement, they have to respond to the email confirming whatever you asked for.
Understandable.
Okay.
Understandable.
Just making sure you understand that. Okay,
No
great. Thank you.
Thank you,
no
Mr.
problem.
Radford.
Thank you.
This is 222485 LT. This is Pinewood Circle versus Robert Crawford.
Good afternoon, Your Honor. Cindy Katz on behalf of plaintiff.
State your name for me, please, sir.
Robert Crawford III.
Mr. Crawford, today is the day and time set for a hearing on plans requested with the Sarah stay that's been in place now for 77 days. Mr. Katz has made representation to the court that there is a consent judgment or agreement between the parties. Mr. Katz, the terms of that agreement.
Your Honor, currently there's a balance due $4,945 of past due rent, $165 of costs for a total of $5,110. Mr. Crawford has until September 26th to pay that amount, and he was advised of MCR 4.201 and did authorize me to submit this to the court with his verbal authority.
Mr. Crawford, what's the status of your SARA application, sir?
I called them. They actually denied me, and they referred me to the do an SER. SER also denied me. I called churches, and just different places. I'm just waiting to hear back from all the places I've reached out to.
Mr. Crawford, in as much as more than 45 days have passed since the Sarah stay went into place and your landlord has not received payment in full from a rental assistance program, this court is required to lift the Sarah stay. Will make indication of the file that that has been done. Mr. Katz has also indicated to the court that the parties have agreed that $4,945 in rent is due and owing. Is that your agreement, sir?
Yes.
Plaintiff has also made a request for cost of $165. That will have a total judgment amount of $5,110. Because the parties appear by Zoom, there is not a signed consent judgment in the file. Mr. Katz has indicated to the court that you have agreed to allow him to sign your signature to the consent before it is submitted to the court. Is that accurate, sir?
Yes.
And Mr. Katz finally advised you that because they are represented and you are an unrepresented party, that you have 3 days to appeal the judgment that this court enters. Do you understand that?
3 days from right now.
Yes, from entry of the judgment, sir.
Okay. Yes, I
Mr.
understand.
Katz's office will now submit that consent judgment to the court for entry. I will sign it. You will get a copy of it in the mail. Anything else, Mr. Crawford?
No. Oh, appreciate y'all. Just hoping for the best. That's all.
Good luck.
Thank
Mr.
you for your patience this afternoon, Mr. Crawford. You have a good one, okay, sir?
All right, you guys as well.
Thank you.
Your Honor, on my last case, she's here. I'm going to pull her into a breakout room and talk about it, and I'll be right back.
Wait, she mock or another one?
Yes, it's an iPhone. So she.
No, that's not my question. Jennifer Mock.
Correct.
Okay, that was
Yep.
my question. Thank you.
Oh, all right. Okay.
Good afternoon, Mr. Hitchcock.
Good afternoon, Judge.
This is 222607 LT. This is Romulus Housing Commission versus Debbie Bruton.
Steve Hitchcock, Your Honor, appearing on behalf of the Romulus Housing Commission. I don't believe Miss Bruton is on the,
Debbie Bruton or anyone from 6344 4th Street in the city of Romulus. Today is the day and time set for a hearing on plaintiff's request to lift the Sarah stay that's been in place now for 84 days. This case was scheduled at 2 p.m. It's now 2:13 by the court's clock. Mr. Hitchcock, it appears that the defendant has failed to appear this afternoon, sir. How do you wish to proceed?
I would like to proceed with a judgment. There's $570 owed plus $83
I'm sorry.
in costs.
You said how much in rent, sir?
$570 in rent and $83 in costs. So total $653.
Inasmuch as the defendant has failed to appear for this duly scheduled hearing, this court will lift the Sarah stay that was previously entered. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $570. There's $83 in court cost due and owing for a total of for a total of $653. Plaintiff's office will submit that judgment to the court for entry. Anything else, Mr. Hitchcock?
Nothing further.
Thank you, sir. Have a good afternoon.
Thank you.
Bye-bye.
Bye.
This is 221767 LT. This is Harbor Club versus Jessica Belcher, Antoine Lee, and Cortex Williams.
Good afternoon again, Your Honor. Daniel Marchese, P75872 plaintiff.
Good afternoon again, sir. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place for 119 days. This case has been scheduled at 2 o'clock. It is now 2:15 by this court's clock. Court's policy is 15 minutes after the scheduled start time. It appears that none of the three named defendants have appeared: Jessica Belcher, Antoine Lee, Cortex Williams, or anyone from 49061 Denton Road, number 304. Based on the defendant's failure to appear this afternoon, sir, how do you wish to proceed?
Your Honor, I'd like to move for a default judgment for defendant's failure to appear. Rents to retain $10,868.04. Court cost $211 for a total amount of $11,079.04.
Based on the defendant's failure to appear this afternoon, plaintiff's request to lift the Sarah stay is in fact granted. Plaintiff is also entitled to entry of default judgment with rent to retain possession of $10,868.04, $211 in court costs, for a total judgment of $11,079.07. Plaintiff's office to submit that default judgment to the court for entry. Anything else in this matter, Mr. Marchese?
No, and Your Honor, I have a 230 case, Deanna Cooper, that we're going to dismiss, and so I will submit that this afternoon as well.
222334 LT, Anmark versus Cooper. The court received the dismissal this morning, signed it, and it's already back downstairs, sir.
Oh, good, thanks. Okay, have a great day.
You too. Thank you, sir.
Okay, bye-bye.
Mary Ann, this is 222439 LT. This is Southport Apartments versus Brittany Millet. Southport Apartments versus Brittany Millet, or anyone at 11022 Oak Lane, number 9104, Belleville, Michigan. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay in this matter. Case was scheduled at 2 o'clock. It is now 2:17 by the court's clock. check the register of actions. There is no update inasmuch as neither party would have appeared. This matter will be dismissed. Mhm. Mary Ann. Mr. Katz and Ms. Mock?
Yes, Jennifer Mott.
This is 222479 LT. This is Pinewood Circle versus Jennifer Mock. Mr. Katz, the court notes your appearance for the record. Ms. Mock, thank you for placing your name on the record. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. It's been in place now for 77 days. The parties have had an opportunity to speak. Mr. Katz, how are we proceeding this afternoon?
Your Honor, we do have a consent judgment in this case. If I could put the terms on the record.
Absolutely.
Your Honor, currently there's a balance due of $5,650 of past due rent, $165 of cost for a total of $5,815. Ms. Mock has until September the 26th to pay that amount. She did indicate that she still has an open Sarah case, so hopefully this will help accelerate the process. For whatever reason, Sarah asked her for confirmation that my client's not participating, which they should never have required after. It doesn't make any sense. Every single one is operated differently. So at this point, hopefully that'll help it along. She was advised Chair 4.1 and did authorize me to submit this with her verbal authority.
Ms. Mock, you were able to hear Mr. Katz just now?
Yes.
And ma'am, it's accurate that your Sarah funding remains in process?
Yes, actually under review.
Under review, thank you. And
Yes,
ma'am, you
ma'am.
understand that because more than 45 days have passed and there's not been any resolution of the application, that this court is required to lift the Sarah stay?
Yes,
And ma'am, you further talked to Mr. Katz and want to agree to entry of a consent judgment that shows that you owe $5,650 in rent, $165 in court costs for a total amount of $5,815.
yes,
And ma'am, because you appear virtually, there is not a signed consent in the file. Are you authorizing Mr. Katz to sign your name to a consent judgment for submission to the court?
yes,
And Mr. Katz also advised you that because you are not represented by an attorney, that the judgment that is entered will not be enforceable for 3 regular business days after it is entered.
yes,
Mr. Katz will submit that signed consent judgment to the court for entry, ma'am. Once the court signs it, a copy will be mailed to you. I would suggest that you take it over to the Sarah people or submit it to the Sarah people, advising them of its entry. Maybe that will help them review your application more quickly. Anything else in this matter, Mr. Katz?
No, I think we're good. I did submit it already
Anything
to
else,
the
Ms.
court.
Mock?
no, no, thank you.
Thank you, ma'am. Good luck to you. Have a good afternoon.
You as well, thank you.
Thank you.
Bye-bye.
Bye-bye. The last thing we have is Fields scheduled at 3 o'clock.
Yep. I will be back shortly for that.
I'll be back when you're back. Thank you, sir.
All right. Thank you, Your Honor.
This is 2349 LT. This is Barrington Romulus Apartments versus Fields.
Tangela Fields.
Thank you, Ms. Fields. Mr. Katz?
Good afternoon, Your Honor.
Today is the day and time set for the hearing on this matter. Mr. Katz, how are we proceeding this afternoon?
So, Your Honor, I did speak with my client. I spoke briefly to Ms. Fields. I do know that they've started some repair work. Now, there wasn't an active leak in her apartment. It was basically an old leak that was not, the ceiling was not fixed. They did patch some stuff up. They still have some more work to do. They are cleaning the carpet, I think, Friday, but I don't know for sure the exact date, but I know it's scheduled. However, as it relates to the balance, I don't know what's going on with Ms. Fields' Sarah application. I do know she indicated that there was a Sarah application. I don't recall, maybe she was denied. No, she wasn't denied.
Sarah had been denied and the
It was
ERAP
denied.
pending.
She said she put money in escrow, but
No, she didn't.
you asked her if I don't remember.
It's
been a long day, Your Honor.
Correct me if it was only a week ago. Ms. Fields, correct me if I'm wrong. I believe the indication was that her Sarah application had been denied. She had applied for ERAP, and although she had some money, it was not segregated in an escrow account, and she had been using some of the money towards other bills that had come due. Is that accurate, Ms. Fields?
Correct. We talked about
And
this
we are
last week.
here on. Yep, we're just recapping because Mr. Katz doesn't remember. He's had a lot of cases between then and now. When we were here last week, the rent that was owing was $5,114. And the court's question to you, ma'am, was regarding the reason for you not paying. Was it financial or was it something else? And that's when you advised of the flooding issues that had left some damage in the apartment, and your request for new carpet. And the conversation that we had was that the court would address it at a hearing today with proof that you had made these requests for repairs, and for Mr. Katz to visit the issue with his client and figure out the status of, or had there been requests for repairs and had those repairs been made. But Mr. Katz, you were starting to say the balance.
Yes, so as of today, this now includes September, there is a balance of $6,198.
Something more pressing than the current case we're on, sir?
No, I'm trying to get my client to log in, so I'm giving her the login ID
Who is your client?
from the Barrington.
What's her name?
It is Nicole, but she said it keeps on giving her an invalid meeting ID. So
You're just making up numbers, sir?
always.
Good afternoon, Ms. Hall.
Hi, how are
What are
you?
you here for?
I'm here to protest a ticket I received outside of my apartment.
No, ma'am.
He gave me a ticket for parking in a handicap.
Miss Hall,
Yes, ma'am.
who gave you a ticket for that?
Romulus Police.
This afternoon, my courtroom only has one case scheduled at 3:00. It's a landlord-tenant case that I'm in the
Okay.
throes of. Are you scheduled to be in court this afternoon?
No, ma'am. I was trying to do the Zoom thing and I'm having a lot of difficulty navigating that. And I just want to get this situation cleared up.
You don't come on Zoom to dispute the ticket. Zoom is where you actually have your hearings. There's an online place for you to text. I'm looking for it right now. There's a way for you to submit your online case review.
Okay.
If you're on the court's main screen, it's on the right-hand side of the page, and you can submit your request to have your case reviewed.
Okay. I'm sorry. So sorry.
No, you're fine.
This
I
is
just
so
let
new
you
to
in
me.
because we were waiting for somebody else to appear.
Oh, okay. All right. Thank you so much, Judge.
Have a good day.
You
Thank you.
I gave her the wrong number.
I told you you're making up numbers.
Yeah, I'm good at it.
That being the case and that repairs in response to the previous flooding are made, and now you're talking about cleaning the carpet on Friday, does that mean that we're having a hearing this afternoon or we're
No,
not?
I think we need to adjourn this as I previously had suggested. We probably need to do.
She's coming. I see your client in our waiting room. I'm bringing her in right now. How long of an adjournment are you looking for?
Well, that's what I would like to know is how long it's going to take till all these items are resolved.
You have to tell me all what items. I know that when we were here last week, you asked Ms. Fields to provide a list. The court was not involved in that. My only notes are regarding the few things, the sink, the flooding issues and the carpet that Ms. Fields raised on the 30th. Was there something else
So,
that you were supposed to
well,
be
what I would
addressing?
say is maybe if the three of us can go into a breakout room so we could just talk it through and make sure that we're all on the same page, because sometimes that doesn't happen.
Ms. Fields, you're going to see an invitation to go into room number 1 with Mr. Katz and Nicole from the Barrington. Please go there and talk with them about this case.
Okay.
Let me know when you're done.
Judge, there's someone coming in for a search warrant.
I know, he's walking in right now.
Okay.
I look up and here comes Crova. I'm good, sir. How are you?
How you doing?
I am super.
I put 3 copies in there.
Why?
So it's up to you.
I only read
You
one.
want to sign one?
Do you swear from the contents of the affidavit or to the best of your knowledge, information, and belief?
I do.
Thank you. What's going on?
So we received a call from UPS about a suspicious package yesterday. Got there, dog hit on it. They opened it per their policies, and it was a kilo of fentanyl. Inside of it was a head of a toy.
A kilo of fentanyl.
It's strong. I never smelled this strong before. It's bad. I mean, it was wrapped. They had it napkin, heat seal, about 15 times. So you had to cut through like 15 layers just to get it open. And when you got it open in the fan, the whole room like almost got knocked out. So we're trying to do an anticipatory search warrant on the house it's going to. That's what I'm asking for today. Came from California.
That is so 80s. They're
Yeah.
shipping drugs through the mail. I didn't know we still did that.
Oh yeah, it's like every day. It's crazy. You actually signed one for me.
I know,
And
I
it was 5
remember.
kilos.
Was it the
5 kilos.
Mexican company?
5 kilos on that one. So
You haven't seen me all day because I've been on the bench. Silly me. You see the gray car in the garage. That's the international sign. My mind wasn't getting over there and getting the trash back inside, so. You know, that's all I'm good for is housework over there. A kilo of fentanyl. I can't believe it. I saw a video online of an officer who accidentally touched it and went down and they had
Oh,
to
yeah.
hit him with 3 Narcans.
yeah, instantly. So this is what was in here. That it was in the head of that thing.
Oh, I know that dog.
Yeah, it's one that dances, right? Or it sings.
It says alphabets and letters.
Yeah.
I've been buying that dog for like
He's
10 years.
awesome.
I give it to all the kids.
Yep.
Who knew the
And
fentanyl
then,
dog?
Wrapped super tight.
If only they use their intelligence for good.
Yeah.
I know that dog. I can't believe it. Holy-
I know, right?
the kids love it. I've been
Yeah.
buying it for all the little kids in our family, like I said, for about 10 years.
It's like the FIFO thing type of deal. Mhm.
You need 3 copies?
No.
Thank you.
Sometimes gotta, like,
I don't like to keep them.
all right.
That's too much paperwork.
Yeah, no, I appreciate it.
You're very
I'll let you
welcome.
know what happens.
Okay,
All right.
have a good afternoon.
You too. Thank you. Be safe. Thanks. See you, Judge.
See you.
Nicole, you can leave.
All right, I will call you back in about 20 minutes.
All right, perfect. Thank you.
Yep.
Parties have had the opportunity to be in a breakout to discuss the repairs. Mr. Katz, where do things stand?
So I did speak with my client. She thinks that the repairs can be completed within the next 2 weeks. At that point, between now and then, I will discuss with my client as far as what is a abatement potential on this and determine what my client is willing to do. And for the record, Ms. Fields, it's shown my client some communication that she has provided, that she has sent since April. My client does not have any records. They went through their entire communication that they get on maintenance requests. The most recent one shows up, but for whatever reason, the prior ones that she had sent copies of were not in their communication log.
Those
So,
were physical emails. Those weren't in because I couldn't get through the app.
right, I'm saying there's a communication log that they have showing all of the emails or all the communication that has come to them as it relates to any maintenance requests. So wherever you sent that, they have the ability to check the historical records.
And is it a tenant portal or are we talking about just an email to a specific?
I'm
email
not sure
address?
whether it's a portal, whether it's an
I'm
email.
asking
whether
Ms. Ms. Fields.
I did a physical email and he's talking probably about the portal that was through the tenant website that I couldn't log into. That I had to physically go into the office because I emailed them to see if I can get in and I didn't get a response. So I went up to the office and talked to Katie because Katie's the only one that I've been working with since I've been there. And she was able to get me into that. But I have not made any maintenance requests through that tenant portal.
Whatever it was that
all
you sent me copies of is whatever they checked. So whatever you sent copies of prior records that you had sent, right?
I understand where you're coming from.
So they checked whatever that was that you had sent it to and
I understand.
checked to see if there was any historical records of it. And they did not have anything.
So where we are, I do believe, is that we are not proceeding this afternoon. Mr. Katz's client needs some time to complete the repairs, which the parties just discussed in the breakout. and we can schedule this matter for actual hearing. I am looking at October the 4th, which is a Tuesday.
At what time?
Is a time better than some other time for you, Ms. Fields?
I can do either early in the morning, because I can get time, like the last time we did was 9:30. I can get some time away from my port truck and have someone cover me, or I can do it after 2:30, because I get off at 2:30. And I just won't work my other job.
It works, whatever works. I'm good with it.
How early could you get off, Ms. Fields?
I have no time to get off work.
You have no time to get off work.
Meaning, like, if I don't have any PTO time, I don't have any vacation time. So if we do it like at 9:30, I can go down an aisle like I did last time and someone will cover me.
If we do it at 2:30, can you log on at 2:30 on the dot, or do you need to be later than 2:30?
That's when I clock out.
Okay. Because we are going by Zoom, let's say October the 4th at 3 p.m. But what I will ask you to do is, because I am not a fan of trying to share screens when you're talking about this serial emails and whatever maintenance requests Mr. Katz's office client has and pictures. If there are documents that you want the court to consider, have them submitted to the court by that Friday before, which would be the 30th, and that goes for Mr. Katz too. You can submit it through the court's online portal on the court's website. There is a contact us button where you can submit proofs, and it allows you to submit those documents electronically, or you can bring a copy to the court or mail a copy to the court. But Ms. Fields, whatever you submit to the court for review, you have to submit identical thing to Mr. Katz's office. The same thing for Mr. Katz. Anything that he wants the court to review and consider on the 4th has to be here at the courthouse by September the 30th.
Okay.
However you submit them, they have to be here, because when we're doing the hearing, it'll be later in the day for us. And when you say email labeled number 1, all of us should be able to turn to it at the same time and review it. Anything else, Mr. Katz?
No, Your Honor, and if we get this resolved before then that will save that need to come to court.
If you do, great. Ms. Fields, if you reach some agreement with Mr. Katz and his client, you can submit it to the court in writing, signed by all parties, and the court will sign off on it. You won't need to reappear on the 4th. Other than that, I will see you on the 4th at 3 p.m., ma'am.
Okay.
Thank you, Your
Same
Honor.
Zoom. Same Zoom number?
Yes, ma'am.
Okay, thank you.
Thank you so much. Have a good afternoon.
Thank you, you too.
Thank you, Your Honor.
Take
Have
care,
a good
Mr.
day.